The broadcast is now starting. All attendees are in listen-only mode.
Okay, welcome everyone to the March 2018 HR Best Practices webinar series. This month we're going to be talking about non-competes and all related things. People generically call it non-competes. It really involves a lot more. It's just technically called restrictive covenants, but I know people generically call them non-competes, so we've called it non-competes under siege. My name is Kevin Mosher. I'm a partner at Thompson Co. in the Minnesota office, and I'm happy to present this webinar to you. If you are new to the webinar series, welcome. And you will, if you are in need of various CLEs that we get approval for, HRCI, SHRM credits, hopefully you've marked the box when you registered that you'll receive those. If you didn't and you need those, definitely reach out to us and we'll get the certifications out to you if we've been approved. And I believe this has already been approved for HRCI and SHRM. We normally get that well in advance. So if you do have any questions along the way, you're welcome to write them on the right side. There is a question box. I will take a look at those periodically as we go through the webinar and try to answer anything that you've got. This webinar is it's non-compete. So this is a legal document. This is an agreement. This is not, some of our, I'm not trying to belittle any of our other topics, but some of the soft, more policy-oriented type of topics that we have, like on immigration and what's going on in the Trump White House and all these things that we typically do. So this one is one of our webinars where we're actually going to talk about documents. So we're going to talk about the law on them, and we're going to talk about what states are doing and what the federal government is doing, and then the basic structure of these non-competes. I mean, these non-competes have great value for businesses, but they are legal documents. So they are the genesis of lawyers, and so that's I'll try not to be too legalese with it today, but that is just the nature of the beast when we talk about non-compete agreements and the like. Okay. So I want to talk about the various types of non-compete agreements, and I normally call them restrictive covenant agreements. So I'm going to use those, synonymously. But a restrictive covenant agreement. So what is a restrictive covenant agreement? Restrictive covenant agreement is any sort of agreement that you enter into with employees. We're going to limit this to an employee situation. You can actually have non-competes and restrictive covenant agreements with other businesses. Like if you buy a business, if you sell a business, you can actually enter into restrictive covenant agreements on the buyer or the seller's side. But we're going to focus, this is HR, so we're going to focus on talking about restrictive covenants in an employment context today. And so restrictive covenants are the broader term used for non-competes, where you're telling an employee that he or she cannot compete, cannot work for a competitor within your industry, within a certain geographic region. We'll break this all down as we discuss these things. We're also going to talk about non-solicitation agreements, which restricts an employee or former employee's ability to solicit your clients or prospective clients for a period of time. We're also going to talk about anti-raid agreements. Anti-raid is they're also called non-solicitation, but it's non-solicitation not of clients but of employees. So an anti-raid, no raiding the company after you have left the company or been fired, no raiding them for the other employees to try to get them to quit or to come and work for a competitor, that sort of thing. So anti-raid. We'll also talk about non-disclosure agreements. And we'll talk about trends and where this is going and the basic structure of all of these sorts of agreements. And I'm sure there'll be some tips along the way. So that's the basic structure of what we're going to talk about today. Like I say, it's not as exciting of a topic as some of the ones that we talk about. I like it. I love non-competes and read a lot of non-competes, and have to try to enforce in court a lot of non-compete agreements. So I find them fun, but they are definitely the product of lawyers, and that's there's a little less fun in anything that comes out of lawyers, it seems. Okay, so what's a restrictive covenant? It restricts the person's enjoyment of certain activities. So a restrictive covenant, you can enter into these assuming, and one thing that we'll talk about like the difference between states and federal government. And so at the federal level, we have like Title VII, and we have the ADA, and we have all these discrimination laws and everything. But then every state, because this is a matter of contract, we look at the states. Every state really has the power to determine what is and what is not a restrictive covenant, what is a contract, and how to enforce a contract, and what are the terms that should be in the contract. That's the from the state. So that's the beast of the state. So all of these things with restrictive covenants, every single state, you're going to need to know it, or you're going to have your lawyers know it, or you're going, whatever. There's no way to talk about this at a federal level like we can with so many of these other issues like immigration and discrimination and accommodations and retaliation. Those are all federal level things, and some of them have state nuances, but for the most part we can talk about them as at a federal level. But when we talk about restrictive covenants, we need to know the exact state that we're in. And that's critical because what one state does, like I'm up here in Minnesota, what Minnesota does with regard to looking at restrictive covenant agreements and enforcing them and saying like what are the elements and everything, that's going to be entirely different than if I'm in Illinois, if I'm in Missouri, if I'm in Texas, if I'm in California. All of those states have different takes on restrictive covenants. So in many ways, what I'm going to be talking about today is generic, and we'll talk about the different states and some breakdowns, but it's pretty generic. Like what is generically across many of the states, what are the typical elements that we see? So okay, so generically, what's a restrictive covenant? Well, by definition, it's something that's going to restrict an employee's ability to do something. So, if I enter into a restrictive covenant, so actually I can't, I'm a lawyer, but no restrictive covenants for lawyers. So if you're a law firm out there, and you use restrictive covenants or you've signed a restrictive covenant, no non-competes anyway. You can have other sorts of restrictive covenants like non-disclosure agreements, but you can't have non-compete. So let's just say I'm an engineer and I'm hired as a new employee, and I enter into an agreement that is going to restrict my ability to work for a competitor both during employment and post-employment. That's a restrictive covenant. If I'm giving up some sort of ability to work, enjoy a living, or pursue some sort of activity, whether it's working for somebody or soliciting clients or soliciting employees that I worked with at my engineering firm, then that's a restrictive covenant. It's stopping me from enjoying what I want to do. Now, in many states, we have a rule. It's called a duty of loyalty. And in many of these states, the courts and the states recognize that a current employee has a duty of loyalty. So whether you have an agreement or not, if I'm in a state that recognizes a duty of loyalty, I actually can't go work for a competitor anyway, just under like state common law principles. I can't go and work for that competitor, so I don't have to sign an agreement for it. I owe a duty of loyalty to my current employer. Let's just go with this engineering, this pretend engineering company. I have a duty to not work for a competitor, to not work against my employer's interests. So if that's what the non-compete is that I'm signing, it's just saying like while I'm employed with this engineering company, I can't work for a competitor. Well, in a state that recognizes a duty of loyalty, and most states do, in one of those states, well, so what? I mean, the state law already does it. I don't need to sign off on a contract. I don't need to sign off on an agreement saying the same thing. So we kind of, again, we need to understand what the state is, but generically, restrictive covenant, that's what it's going to do. It can restrict what I'm doing during my employment with a company and then after the employment with a company. These are the types. Talked about them a little bit already. We've got a non-compete agreement, which says that I cannot work for a period of time after employment during or after employment with a competitor. And we want to get as specific and narrow as possible with that. Like, what is a competitor? Is it in the same industry? Is it in the same geographic region? We're going to want to define all those things. We'll talk about that in a minute. Non-solicitation agreement says I can't solicit clients, maybe even prospective clients. Some states will allow you to restrict employees once they leave your work environment. They'll say that you can't solicit prospective clients, maybe clients that you had solicited for work, as let's just call it a salesperson, or clients that you had worked with as a consultant, that you can't go and solicit them for work or to leave the relationship that they have with your current or former employer. Anti-rating stops you from being able to solicit employees of your probably former employer. Can't get those people to quit. Confidentiality, that's pretty standard. A lot of companies have confidentiality, and you'll throw it even in employee handbooks at some point. I generally recommend, if you're going to do it in an employment handbook, you have a separate sign-off for it. We want to have that. We want to have a confidentiality agreement with employees, or a non-disclosure agreement, NDA. We want to have those carved out separately. It can be part of the handbook, but it should be a rider to the handbook that's separately signed off on. We want to, because the reason is, if we ever have to go and enforce it in court, we want to be able to take that to we want to be able to take that to the court and just make a print off and show that the person knew what they were doing, with regard to that. They knew that they were signing off on this confidentiality. Same with non-compete, same with non-solicitation, same with anti-rating. I generally do not recommend putting these just like within the litany of verbiage that goes into an employment handbook. They should be pulled out. They should be separated. We want to make sure that the employee knows what they're signing off on. Somebody asked the question, and thank you for the first question. Somebody asked the question of whether or not states publish what they consider enforceable with regard to non-competes. And you might be able to find some resources out there, but for the most part, no. For the most part, it is not easy to just do a Google keyword search to find government issued information on non-competes. And the reason is because we've got two types of laws, right? We've got statutes that state legislatures make, and then they're signed off by the governor, and they become acts of law. And so that's defined, and we can that's easy to research, and that's easy to figure out, because they write the language and they say exactly what they want to say and what's restricted and what they allow and that sort of thing. But then we've got these common law principles, and matters of contract are generally common law principles, and common law principles tend to derive from common law, which is hundreds of years old and has been then refined and interpreted by the courts. And so because most every state doesn't have some sort of statute on non-competes and non-solicits and confidentiality agreements and that sort of thing, because there's no law per se that you can go and look at in statute form, it's up to the courts have used jurisprudence to define these things. And as a result, that's why you often need, that's one of the reasons you need attorneys to really figure this out, because the laws, the ways that courts interpret things change. And in fact, every day judges feel like on this issue that they have a lot of discretion. And so what one judge does with regard to a non-compete agreement here in Hennepin County might be entirely different than what a judge does in Cook County in Illinois, or in Dallas, or in Los Angeles County. it's really hard to figure out what the courts are going to do with these non-competes. But to figure out in most states, you need to look at what the courts are doing and what the judges are doing and how they view these, how hostile are they to them. And that's why writing these non-competes, you just can't generically write them. You can't pull something off the internet and say, well, this worked. I found that this big company based out of Seattle, did this wrote this agreement. That's going to work as well in Missouri. That's just not the case. Every state, every judge, every county, you really need to understand where you're going to enforce these things. And so as a result, you're not going to find much in the way of state resources, because most of these states, there's no like law per se written on the books. So thanks for the question. So why would we have restrictive covenants? Litany of reasons. We want to make sure to protect our clients. Our clients, and especially if you're in a service industry, but even if you're selling product, your clients, your contacts, your vendors, your customers, they are critical to your business. There are very few businesses where clients and customers and are not critical. And I'm at a complete loss as to figure out. I suppose the government, would be one, but we don't really care about them for purposes of this conversation. But in private industry, for the most part, the value of your goodwill, of your client base, of your customer base, the way that you're perceived in the marketplace, that's the value of your company. You might have other things that add to that value, but certainly if you're in a service industry, that's the majority of your value. And so we want to reduce the chance that one of our employees who we bring in to train, and we spend resources on training, that one of our employees then goes and ruins or hurts or steals, however you want to put it, the goodwill, the customers that we've built. And so, as a result, because we're going to train employees, a lot of businesses, because they're going to train employees, want to then protect that investment. And how do you protect that investment? Well, not through goodwill and not through being nice. I mean, that's great. And if it works for you, that's fantastic. But the reality is that, people are in it for themselves for the most part, and not everybody, but for the most part. And so as a result, we want to protect our investment. And so we want to protect our own clients and customers. And so the way we can do this is by doing a restrictive covenant, a non-compete agreement, a non-solicitation agreement. And we can give that employee pause to think that, hey, before I go and steal this customer, I better think twice about it before I end up embroiled in a lawsuit. And so we want to stop them. We want to protect our investment. We want to protect our business. Our trade secrets are part of the value of that business. We also want to make employees, we want to stop them from fleeing the ship. Now, most companies, it's employment at will, and very few employers outside of the C-suite will have contracts with employees. We might have some sort of employment agreement, but for the most part, even employment agreements are going to be employment at will. And so we want to protect our employees from leaving. And so if one employee leaves, we don't want that one employee to steal all the other employees. So we want a restrictive covenant agreement in place saying, hey, no rating us. If you leave, 2 years, 3 years, 1 year, whatever it is, 18 months, we don't want you calling your former coworkers and stealing them and taking them away from us. They're valuable. We've got an investment in them. We don't want you taking that whole team. We don't want you pilfering from us and hurting our core business. Some industries, it's more common than not. So if you're in IT, it's pretty common to have. If you're in sales, it's pretty common. If you're in law, it's entirely uncommon because it's for the most part illegal. But in a lot of industries, medical, the funny thing I always, when I first started doing this, long ago, and had my first enforcement of a doctor who left the medical practice, and I was just like, oh, so yeah, doctors, I was a brand new lawyer. I was like, oh, doctors we can enforce non-competes against, but not lawyers. I guess society thinks it's more important for lawyers to be able to move around from law firm to law firm and be able to take their clients with them versus doctors who just because they're saving lives and that sort of thing, we can actually stop them from going and working down the street and opening up their own practice if, in many states, if we have the right agreements in place. Here's a list of some of the industries that's pretty common. Financial, for sure, financial industry. We see that on Wall Street a lot. IT, sales, medical. And like I say, if you're doing non-competes, if you're doing restrictive covenant agreements and you're doing, any of these where it's confidentiality or non-disclosure agreements or anti-raid or non-solicitation of customers and clients or non-compete of, don't go work within this geographic region. If you're doing any of that, then you need to know, like, where am I going to enforce it? If the employee is working in Kansas City, what does Kansas City say about it? What does the state say about it? What do the judges in that jurisdiction say about it? Is it split? Are some judges going to allow it and some not going to allow it? What's the trend on this? This all needs to be understood before you really start to even worry about putting pen to paper on this. It's critical if you actually want to enforce it. Now, I will say a lot of companies don't really care that much about enforcing non-competes, and that's fine. Don't waste the money enforcing it if you don't really care. A lot of employees are just going to be scared. So if you just do a non-compete and you put it in a bunch of language and you make it sound like a lawyer, or maybe even a lawyer did write it for you, but then told you it probably wasn't going to be enforceable, could that give an employee pause? Sure, like an unsophisticated employee that doesn't bother telling the new employer or doesn't bother getting a lawyer to say, well, the thing's garbage, this agreement's garbage, you're not going to be able to, and they're not going to be able to enforce it. I mean, a lot of employees don't even want to hassle with it, so they'll probably kowtow to and follow what the agreement says. So there could be value in an agreement that's entirely unenforceable. But for the most part, if you're going to bother, you should probably try to make sure that it's enforceable, at least to the best of your ability. There's no guarantees with any of these non-competes. I incorrectly hear from people all the time that, so-and-so lawyer said, non-competes aren't worth the paper they're written on. Absolutely false. Non-compete agreements in Minnesota and most other states are enforced all the time against employees, against former employees, and that happens all the time. In non-compete agreements, restrictive covenant agreements get enforced. That's true. If people tell you otherwise, then they're uninformed, because they get enforced all the time. Is it easy to enforce it? Are they enforced most of the time? Probably not. Is it easy to enforce it? Not in most places. Courts get pretty hostile to these things. They don't like them. But some judges are okay with it. The interesting thing is, after you read, a couple hundred decisions on these, you realize that so many of the cases that the judges will start out like this. They'll write the case and they'll say something like this: our state law disfavors non-compete agreements and stopping and restricting the trade of employees and being able to go and find a new job and make a livelihood for themselves. Our state strongly disfavors that sort of restraint on free trade. However, we also recognize that businesses have a vested interest in this. They invest in employees. They expect employees to adhere to contracts. And when these things are reasonably written, and reasonableness is a completely, nuanced concept that's going to be state by state and county by county determined. But when they're reasonably written, then in those situations, courts uphold them all the time. And so a court will talk about how generally we disfavor these things. However, here we are enforcing it right now and telling you that you cannot go work across the street after you worked for a business for 5 years and you signed a non-compete agreement. Are these things more enforceable in a good economy or a bad economy? Yeah, I mean, that changes things too. Society's view on these things, like I say, where there's no law to interpret, where the state hasn't done an actual contract, it's just it's kind of up to a lot of judicial discretion, which is good and bad. And normally it's bad just because we like to be able to foresee how these things play out, but it can be good too, I suppose. So I already talked about this a little bit, but what is a non-compete? Actually, somebody looks like question. Somebody asked, as a separate document for a non-disclosure agreement, for a non-solicitation, for a non-compete agreement, is the employment agreement an appropriate document? And the answer is yes. An employment agreement, if you're doing an employment agreement with somebody, and all employment agreements can look differently, but an employment agreement is a separate, that's normally like part and parcel of an offer letter. You give an employment agreement to somebody before employment starts, and you incorporate into it a bunch of terms regarding their employment. And it could be non-competes are thrown in there, non-solicitations, confidentiality, that sort of thing. That's entirely the correct place for these things. It's not part of the handbook. It's part of a separate document. It's an agreement between you and the employee. The key is, in most states, you need to have that employee, most everywhere that I can think of off the top of my head, you need to have that employee sign off on that employment agreement before they start to work. And we'll talk about consideration in a minute, but that's the key with the the employment agreement, and any of these, they have to sign off before they start to work. Restricted employment. So non-competes, what do? They basically tell employees, after you've left or even during your employment, you can't go work for a competitor. You're restricted from working, not from living, not from going and buying a candy bar. You're restricted from working within a geographic scope. That geographic scope needs to be limited. Some states don't care as much as others. Some states will say, well, what's limited? And I will tell you, limited is going to come down to the circumstances. For example, some of you may have heard rural Minnesota doesn't have a lot of people living in it. So a 100-mile radius from northern Minnesota up by the Canadian border, that's going to get a lot of moose and a lot of wolves and but it's not going to get a lot of people. So a 100-mile radius is going to be beautiful up there, but it's not going to encompass a lot of people. Well, and a lot of work. So if you do a 100-mile radius and you say, look, I brought you up here from Texas, you wanted to get up to the Northwoods, and you wanted to, be a dentist up here, fine, but I pull from a 100-mile radius for my dental practice because there aren't a lot of dentists up here, and so people drive. So 100 miles is the scope of my business. So you cannot, if you leave me, you cannot go and work within 100 miles of my dental office. Okay, so very reasonable, 100 miles, and that makes sense. Like that's the guy's dental practice, and so you're bringing this person in, you make them sign a non-compete, say you can't work within 100 miles of the dental practice. Makes a whole lot of sense, and is probably who knows. It's always hard to know, but I would say you have a pretty good chance of getting that enforced. If you do 100 miles from New York City, good luck. It's going to be pretty tough. That's going to incorporate most of the state and millions and millions and millions of people and tens of thousands, maybe more jobs. Businesses, separate businesses are going to be within that same geographic area. Same with any. So when we're talking about New York City versus northern Minnesota, we're talking about completely different circumstances. You're not likely to be able to enforce a 100-mile geographic scope in New York City. You might be able to enforce like the city, maybe 5 miles, 2 miles, 3 miles, something like that. A lot of this is going to depend on the nature of your business and the scope of your business and how far you go out. Some companies will try to get the entire world, the entire United States, the entire, Europe and the United States as part of the geographic scope, and good luck enforcing that. There are some states that might allow for it, and maybe you can make a cogent argument that this is, the person's a salesperson for the entire United States, and so they're restricted from working, and they need to be restricted from working as a salesperson in the entire United States. And maybe you find a court that enforces that, but not many will. there's just, so we just need to look, but we have to look at the circumstances. It has to be reasonable for a period of time, and the reasonableness for a period of time is again going to be court by court. Normally you're good at a year. 2 years, probably good. 3 years, 10 years ago, I used to say 3 years, not a big deal in most states, but nowadays 3 years, probably pushing it. Beyond 3 years, you're going to have a really hard time enforcing it. So if you're going to tell somebody that they can't work within 100 miles as a dentist within 100 miles of a town in northern Minnesota, I think geographically it's pretty reasonable, but you're not going to be able to get it for 5 years. Not likely. You're not going to likely be able to get it for 4 years. 3 years, little chance, maybe. 2 years, pretty good chance. 1 year, really good chance. 6 months, absolutely. Really like that, like the odds on that. So, confidentiality. What does a confidentiality agreement do? Restricts the disclosure of certain types of information, limits the certain type of information, basically says when you leave, you can't take trade secrets with you. You cannot take our proprietary confidential information. If the information's out there in the public sector, the public sphere, and people know about it, so let's just say Coke gave up its recipe for Coca-Cola, and everybody knows it. It's on the internet, and everybody knows about it. Well, you're not really going to be able to enforce a confidentiality agreement or trade secret. Stop an employee from talking about the recipe for Coca-Cola because it's already been disclosed. It's already out there. But information like client lists and marketing strategies and financial information about the company, are those the sorts of things that in most states we can stop employees from talking about after they leave employment? Yes. That's the type of stuff that's proprietary business information that we know about as a company, and that you've been given because of your employment relationship, and you wouldn't have it but for the employment relationship. So that's the sort of information that we can put into a confidentiality agreement. And again, this all has to be in writing. All these things have to be in writing, otherwise you cannot enforce them. If you just have a conversation with somebody and you say, you can't talk about proprietary business information, that you can't solicit employees, coworkers, right? I mean, you agree, nod, right? You're not gonna do that. You're not gonna be able to enforce that. I'd be amazed. I've never heard of a situation where you could enforce a verbal contract like that with regard to a restrictive covenant agreement. So you need this all in writing. Lawyers need to write this for you. This is what lawyers do, and but if you don't care about enforcing it, then you probably don't need a lawyer to write it. But if you care about actually having it worth the paper it's written on, you need legal assistance. Anti-raid stops employees from raiding your workforce. So they leave, and then you don't want them to call up their coworkers and say, it sure is better over here. The grass is greener. It is greener. And so come on over. And then suddenly, before you know it, your entire team of workers is gone. And it's all because this former employee has solicited them. Non-solicitation is with regard to customers or clients. Says that they cannot, once they leave, they can go work for a competitor. Fine. Let's just say there's no non-compete. They can go work for a competitor, but they can't go and solicit your clients. They can't go and solicit your customers. It's much easier to get, in most places, it's much easier to get a non-solicitation enforced. I think judges, courts understand that it's a pretty crappy deal that if you've been given access to customers, that you would then trade on that access and go in and benefit from it personally with a new employer by soliciting that customer. I think it's easier to tell for a court to say, no, stay away from the customers, at least for a couple years. Stay away from them. That's easier for a court to tell somebody to do than to say, you know what, you can't work as a dentist. I mean, I know you're a dentist. Like, that's your trade. Like, you can't do anything else. Lumberjacking, not your thing. So kayak tours, mining, things that, go on in northern Minnesota, like those aren't hunting, professional hunters, like those aren't, you're a dentist, right? So it's hard for courts to tell people that they just can't work at all within a certain field. But I think it's a lot easier for courts to say, look, go ahead and work. Like, we don't want to stop you from having a job. We want people to have jobs, but just stay away from these clients, stay away from these customers. That those belong right now, to your former employer. You've signed off on an agreement. Stay away from them. Looks like somebody else asked a question. Somebody asked it says that it seems logical that confidentiality is a duty of an employee, whether there's an agreement or not. I agree with that. Every state's a little bit different on that. And so when we talk about non-disclosure and confidentiality, however, most of the confidentiality agreements that we're talking about are with regard to post-employment. So, there are certain things that you just can't disclose under various, states do protect certain information from disclosure, even post-employment. But for the most part, we still want to have confidentiality agreements in place to protect post-employment disclosures. But I agree with you otherwise that, generally a lot of courts, a lot of states will generally recognize that employees, through their duty of loyalty and other protections, that there is some sort of confidentiality protection in place. Common elements among all these restrictive covenants, they're matters of contract. They have to be in writing. They have to be clear. So I have a 14-year-old. I'm as of like a couple days ago. So that's great and all, except he's getting older and whatever. So he's a solid teenager now. And I say this: if you write it so that a 14-year-old, middle schooler, can't understand it, or somebody with no college education, if they can't understand it, then go back to the drawing board. It needs to be clearly, concisely written. These things, again, lawyers draft them, so they're always going to be convoluted, right? I'm kind of being a little facetious, but they need to be clear. They need to be, I hate to say dumbed down, but they kind of need to be dumbed down. They need to be understood. If an employee signs this and they say, I didn't really understand what I was writing, and even though they had the opportunity to get a lawyer, it's just going to muddy the ability for you to enforce it. If you want this to be enforced, it needs to be in writing. It needs to be narrow. It needs to be limited in scope. It needs to be limited in duration. It needs to be clean and clear and easily understood. And if a 14-year-old can understand it, there's a pretty good chance a judge can understand it. And so, and an employee can understand it. And so I kind of think of that, like, can my middle schooler understand that if I were to put this in front of him, that, he is restricted from doing, anti-raid and non-solicit, non-compete, that sort of thing. And then there has to be consideration. We're going to talk about consideration in a minute, and that'll be your legal term for the day. So it's like, what do they call it in movies? Shoot. Okay. Well, anyway, legal term of the day. That'll be it. Common mistakes. Where do employers make mistakes? Employers, lawyers. Where do they make mistakes? They write these things so that only lawyers can understand them. Big mistake. Good luck enforcing that. Maybe you got a really sophisticated judge that's pro-business. That absolutely could happen. But if you want a better chance in most jurisdictions, you're going to want to draft that really cleanly. If you can't understand it, it'll be difficult to enforce. If you have to overly explain it to a judge, it's going to be difficult for that judge to enforce it, because again, in most states, there's the disposition the disposition is that we don't like these things. So you're going to get automatic hostility from most places in the United States. You're going to get some hostility because they just generally don't like to tell people in an at-will context that they can't work somewhere, that they can't talk, that they can't solicit, that they can't try to make a living by getting new clients and customers, even people that they worked with at a previous employer. It's hard for judges to do that. And so you have to make a case. And one of the ways to screw it up is by having a really convoluted document that just doesn't make sense and is hard to put together and isn't narrowly written. And then not providing consideration, which is a huge mistake that should be like restrictive covenants 901, and we'll talk about that in a second. At the bottom, you can see overreaching, wanting too much, not limiting the scope of the duration. I understand you might want that dentist in northern Minnesota. You brought him up from Dallas, you trained the dentist, you introduced the dentist to all of your customers, and it just didn't work out. And the dentist then, I mean, I understand you don't want that you want that dentist to basically go back to Dallas and to go back and enjoy a new dental practice, but he's up in northern Minnesota. And so you don't want to say restricted from working in the entire state if your dental practice only goes about 100 miles. So don't overreach. If your business competes and really only pulls clients and customers from a 5-mile radius, don't put a 10-mile non-compete on an employee. Don't say that they can't go work for a customer within 10 miles. That's not reasonable. You're overreaching. Some courts might excuse it. They might call it what's called blue pencil. They might restrict it back. They might dial you back to 5 miles after you put out evidence showing that 5 miles is your business radius. And they might, in some states, allow for blue penciling, where they just say, you know what, you overreached on this one. We're just gonna write in. We're gonna make it 5 miles, and they just basically amend your agreement and say, you know what, buddy, no going and working within 5 miles. So even though your agreement said 10 miles, a judge did a kindness by you and edited your agreement, blue penciled it down to 5 miles, which is great if you're in a blue pencil jurisdiction. But for the most part, a lot of jurisdictions, if you overreach and you say 10 miles, a lot of those courts will say, you know what, overreach. Your business only goes 5 miles. You ask for 10 miles. It seems that you're trying to be pretty punitive on this person. We don't like it. They're going to nullify the whole thing, or at least not enforce it. Just say you're not going to enforce it. You tried too hard. If you find out somebody's violated it and you don't bring a lawsuit right away, you potentially are waiving it. A lot of courts, I don't know if it's the majority in the United States or not, but a lot of courts will look at that and they'll say, you know what, wink, wink, nod, nod. You really didn't care. Now, why do you care? Now you're trying to enforce it. You sat on this for 2 months. You sat on it for a month. You sat on it for 6 months. Now you care? Well, I'm not going to enforce it against somebody after you snoozed on it. So if you find out that somebody's violating the non-compete agreement, the restrictive covenant agreement, they're soliciting employees, there needs to be a protocol. Normally the protocol is we send a nasty letter before we jump into court. You normally send a letter threatening a lawsuit, telling them to knock it off. And if they don't knock it off, then you need to look at getting a restraining order, jumping in, TRO, getting a permanent injunction eventually against them to try to enforce it. But that's how those are some of the mistakes that businesses often make. Good question on non-competes. If a non-compete does not have a geographic limitation on it, does that automatically crush it? In most jurisdictions that I'm familiar with, yes. If you have a non-compete, no geographic limitation, you just say you can't work for any competitor in this industry in the entire United States, or it's just not even defined by the United States, just like any competitor in the industry, you're not likely to be able to enforce it. If you don't have to put a geographic limitation on a non-solicitation, however, you could just say if you've worked for any customer that you've worked with, or any customer that we've done work with for the last 2 years, you cannot solicit them to leave us or for work for business at your future employers for 2 years. You can do that. You don't have to have a geographic. In most jurisdictions that I'm familiar with, you don't have to have a geographic limitation on a non-solicitation agreement, but you almost certainly are going to have to with a non-compete. Trends that we're seeing in some states, let's just call them blue-leaning, more liberal states, like Illinois, Massachusetts, New York. I think Hawaii's a little bit doing some of this. We are starting to see in the last 2-3 years, we are starting to see attorneys general go after businesses that are enforcing non-competes, or at least have non-competes in place, and they argue that it's unconscionable normally for low-wage workers. So in Illinois, they passed a law that said basically if you're making less than $13 an hour, you can't have a non-compete with somebody. They're making too little money for you to have a non-compete against. The Obama White House in 2016, they put out an analysis of non-competes, and again, these aren't federal issues, so it's a little weird to have the White House look at this, but they did, and is important to them. So they put out basically a primer on non-competes, saying that they basically said, they can be good for businesses and it's important for businesses and all that sort of stuff. So they said a bunch of good things for businesses, but they also said, hey, it also restricts trade, and we don't like it for low-wage workers. It's not fair on low-wage workers, especially in like the hospitality industry, as the argument goes. It's not fair to restrict them from going and working for somebody else at another hotel or at another restaurant. Or at another like amusement park. It's just not fair. They're not making enough money. If you're going to do non-competes, do it for people that are making more money. IT professionals, finance, people on Wall Street, doctors, dentists, those sorts of people. Do the non-competes for those people. They make plenty of money. So there have been several lawsuits from attorneys general in Massachusetts and New York, for example, Illinois as well. But Illinois actually passed a law on this a couple of years ago. But attorneys general have actually brought a bunch of lawsuits. I shouldn't say a bunch, but they've brought some lawsuits arguing this unconscionability thing, taking kind of a page out of the Obama White House published report, and saying, yeah, you shouldn't be trying to enforce non-competes against low-wage workers. We don't like that. State restrictions. And again, these are the restrictions that these are trends commonly see among states. So we see states that talk about trade secrets and allow you to, they tend to enforce trade secrets, confidential information. There may be some sort of geographical reach. So anyway, these are some of the elements that a bunch of the states will look at with non-competes when they're doing the analysis to figure out if the judges in those states, if they're going to enforce these restrictive covenant agreements. They're going to look at all these things: fairness, are they too broad, overreach, limitations on geographic, limitations on duration, that sort of thing. Is it a trade secret versus just proprietary information? Trade secrets more likely to be enforceable. Proprietary information belongs to the company, but it's not necessarily like a trade secret per se. Proprietary information can certainly be restricted, but it's not as likely. It's just not as high of a level as a trade secret. States, just very general chart showing, states where, for the most part, you can get restrictive covenants enforced. And then there are a few states where, good luck. Pretty much no, you're not going to get restrictive covenant agreements enforced, at least not non-competes. Illinois, again, there are a lot of states where it's like, here are some nuances to it, like in Massachusetts and Illinois, there's some nuances to it, but for the most part, we've got 3 states that are hard nose, and the rest of the states, you've got a fighting chance, or at least a chance. Okay, I talked about consideration, and when I say consideration, this is where a lot of agreements fail. And consideration is basically, I need to give you something in order to entice you to sign this writing that's going to restrict you post-employment. So I need to give you something. Now, what is that something? In most every state that I'm familiar with, except for the ones that are hard nose, obviously, you can do consideration, which is the job. The job is, if you want this job, you need to sign off on this agreement. Most states will recognize that's happened. Now, in order to get that to be enforceable, you need to ensure that the employee signs off on it before they start working. A lot of courts out there will say, look, if you've already started working and then you sign the non-compete agreement, saying that post-employment there's no consideration there because you've already got the job. You're already working the job. So you got to have this signed off. I mean, at the latest, a lot of courts will allow, at the latest, do it as part of the orientation first day. If you can do it before they start working their first day, even even better. But there's got to be something of value. If it's a current employee, you normally, in a lot of states are split on this, a lot of states will say consideration would be continued employment. I go to an employee and I say, look, I'm going to fire you unless you sign this non-compete agreement. Okay, a lot of states that works. Not in Minnesota. In Minnesota, that doesn't work. Some states it does, some states it doesn't. And Illinois got their own, nuances with that. But again, depends on what the courts have done. For the most part, to ensure consideration, we have to give something. Normally it's a raise or a bonus or a one-time bonus, something like that. But we have to give something of value. So if I'm in Minnesota, I need to give something of value to an employee who's a current employee if I want them to sign a restrictive covenant agreement. And it could be $100, it could be $50, it could be $500. The more money I give them, the less this issue of consideration is going to be argued once I try to enforce the restrictive covenant agreement. So we need to, again, every state, every court's going to be different on what consideration is, but for the most part, you can do it for new employees before they start employment. If you're going to do it for current employees, you got to know what your state says. Duration. Again, I already talked about duration. 1 year, pretty likely to be enforced. 2 years, potentially enforced. Also, what courts will also look at is, so in Illinois is a good example of this, courts will also say, well, we might not enforce a 2-year restrictive covenant agreement for an employee that worked for you for 3 months. That doesn't seem very fair. And so an Illinois judge might blue pencil that down to 3 months. They worked for you for 3 months. They're restricted from working for a competitor for 3 months. That makes sense to us. So the length of the employment, the nature of the training, these are all going to be factors. How much investment was put in? Did you move the person from Dallas up to northern Minnesota? Or did you just find them? Were they just like a local boy from Minnesota that came to work for the dental practice? The more investment you make in the employee and training and moving and all these expenses, the more likely you are to get enforceability and to have a longer duration. We've talked about geographical. These are the other common elements. What does it look like in the industry? What is the nature of your business? How far is your scope? How far are you drawing clients? Is the person, traveling around to multiple offices? Is this truly a U.S., an entire United States geographic, practice and business? You need to look at and understand what the scope of your business is and what your industry is and clients and all that when you're doing the geographic limitation. Because again, if you overreach and you don't have any geographic limitation, or if you have too broad of one, it could undermine the entire agreement. Generic framework. Here's what I don't recommend any non-lawyers writing these. Definitely advise against that. But here's the generic framework for a restrictive covenant agreement. You describe the nature of the agreement. You're going to describe the work to be performed by the company, like what that person's going to do for the company, what's their job and duties and that sort of thing. You talk about the industry. You talk about how competitive the industry is. You talk about the need for confidentiality within the industry. You describe clearly the consideration. Is the consideration that you don't get this job unless you sign this before your first day? Is the consideration we're going to give you $500 as an enticement to sign this agreement? Whatever it is, you have to put it in there. Then you describe the restriction. Is it going to be an NDA? Is it going to be a non-solicit? Is it going to be all the above? Is it going to be non-compete? Is it going to be all the above? You pick and choose what you want in there. And then there are just going to be some standard contract clauses on jurisdiction and choice of law and that sort of thing. And then the employee has to sign and date it. And they have to sign and date it. Electronic signatures, that's fine. But you need some sort of acknowledgement electronically or in writing that the employee has agreed to be restricted from this. I'm going to skip these. We've kind of already talked about all of these. Let's talk about a few, since I already covered that stuff, let's talk about just a few states, and then I think we're done. So in California, good luck. There's a law specifically on the books, and like I said, most states don't have laws, but California does have laws, shocking, on this. So there are some nuances to it. I would never say like a, I don't think California lawyers would probably say it's 100% no, but it certainly is going to be 100% no on certain types of restrictive covenant agreements. But for the most part, they would need to be, very narrowly tailored, and you're almost not, and certainly not going to be able to get a non-compete, but you might be able to get some restrictions on confidentiality and disclosure and that sort of thing. But California's our outlier. Again, we're all surprised, but California's our outlier here, where they actually have something statute on the books that expressly says that we hate non-compete agreements and don't enter into them. Texas, you can get non-competes in Texas. You can have non-competes, you can have non-solicitations, you can have all the above. They've got to be reasonable in duration, in industry. You can't, in most every state, just like Texas and Minnesota and Illinois, you're not going to have a non-compete enforced, almost certainly not enforced, where you say you just can't work at all within 5 miles. Like no working at all within 5 miles of my business. I don't even want to see you. I don't want to see you with any other company. Almost certainly you're not going to be able to get that enforced. You're going to need to limit it to the industry. So if I work as a dentist, I'm going to say, look, you can't work as a dentist within 5 miles. Can you go work as a lawyer? Knock yourself out. I don't care. I'm a dentist. Like, why would I care? I'm not here to punish. And the courts aren't going to want to punish somebody. So if you restrict the work to just dental work, fine. You're probably, Texas, you're pretty good chance of getting that enforced. And you have to understand your business. You've got to understand your business. You've got to understand and then write and tailor the restriction to the business itself. Oops. Oh, thought I had. Oh, Massachusetts. I'm sorry. I totally skipped. I've got on the right side of my screen, I've got like the stuff on, just like you have on the right side of your screen, and it completely was blocking. Okay, so we've got 2 more I'll cover, and then we'll go here. So in Illinois, we've got actually a law in Illinois that says that you can't have a non-compete agreement for low-wage workers, and they define low-wage workers as people working less than minimum wage and people working less than $13 an hour. So might be $13.50, but anyway, we're talking about low-wage workers, so you're not going to be able to do that in Illinois. Illinois also has some nuances where the courts have said, look, if you're working, like I'd mentioned before, if you're working for a company for 6 months, good luck trying. It's not fair that you're going to be able to restrict them from not working or soliciting clients for 1 year or 2 years. They only worked for you for 6 months. I mean, let's be equitable with this. Illinois generally will say that 2 years is kind of the top end for enforcement of restrictive covenants, of non-solicitation agreements and non-compete agreements. Illinois, like a lot of states, will also look at the hardship on the public, right? It's a hardship on the public if people can't go and work where their skills are necessary. Massachusetts is nuanced. They've proposed some legislation out there to try to restrict non-competes and to stop employers, especially low-wage workers, like Illinois and like New York has done with Attorney General's actions. So. But Massachusetts they will enforce, judges will enforce, again, maybe not every judge, but judges, have and will enforce trade secrets, confidential information, good, and that sort of thing. And they'll look at non-solicitation agreements, and they'll just make sure that it's tailored to the business and the need, and that the harm to the employer would outweigh the harm to the employee. And so, courts will actually consider the harm to the employer. And even the Obama administration, when they did their review of this in 2016, even they said, employers have vested interest in here. We want to make sure to protect employers' interests, and most judges will look at that as well, which means when we go to enforce these things, we have to really articulate why it's in our best interest. We're not just trying to be mean and retaliatory and hurt people and stop them from working. So it is a couple seconds before 1 o'clock. So thank you. I really appreciate your time today. And if anybody has any further questions, thank you for all the great questions along the way today. I really appreciate it. Our next webinar will be on millennials in the workplace. Really excited about that one. Haven't talked on that one in years. And so we're going to talk about generational differences in the workplace and how to deal with them in HR. Thank you. Feel free to reach out to me. Again, it's Kevin Mosher at Thompson Co. with any questions or comments that you have regarding this presentation. Thank you.